Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather, and we're here in SoCal. Had a nice conversation with Dr. Owen Anderson yesterday. Today, we're getting back into the Bostock dissents. We're two more from being done with Alito, joined by what's his name? Two more joined by Lee. I just got a message from Zoom. I'm not sure why. What the heck happened? Let me pause this for a sec. So, like I said, we're in Bostock versus Clayton County, Alito's dissent, joined by Thomas. We're in Roman numeral 2B. B is in dog. Just kidding. B is in boy. And B as in boy only has one short paragraph, but it's on page. If you go to Google Scholar, you'll find the pagination does not line up with the U.S. reports, like I've said a million times. But Alito's dissent starts at 1755 of the Supreme Court Reporter on Google or Giggle Scholar, and we've done Roman numeral 1A. And I think we're on Roman numeral 1B. Okay. So I'm hoping that you're enjoying this. It's deep work. We're going to go through B1, 2, 3, Roman numeral 2A, B1, B2, um, through C, and we're going to stop at D, Roman numeral 2D, and that will be halfway through, almost exactly the rest of the way that we have to go for Alito's dissent, joined by Thomas. Then we will have another episode for that, and we'll do Kavanaugh's dissent in a separate but equal episode after that. Recall, this is about the 1964 Civil Rights Act, the language of sex discrimination in Title VII, and the federal liability which attaches to what the court now newly takes to be a violation for the first time in American history that we've had the Civil Rights Act of 1964, Title VII, applying the word sex discrimination to any kind of consideration that an employer might want as a matter of discretion over hiring, firing, promoting um, homosexuals or people that say they are transgender. The question the court asks and answers here in Bostock versus Clayton County is whether the 1964 Civil Rights Act language of sex discrimination in Title VII includes, reaches so-called transgender identity status or homosexuality. Alito and Thomas here are disagreeing with the court's decision that the word sex in 1964 Civil Rights Act Title VII reaches properly something as questionable, metaphysically questionable as transgender status, although they don't use a metaphysical argument like I do. That's my spin on what they're saying. They're proceeding purely textually, saying this is bad statutory construction. Sex discrimination does not include properly anything related to sex. That would be absurd. Anything that attaches to the word sex, that would be absurd. And that's the argument that they've made so far, I think, pretty well. Although the court relies, and when they say the court here, Alito is saying Gorsuch's opinion for the court, the majority opinion in Bostock versus Clayton County. Remember, Gorsuch is a Republican. Two Republicans were on the majority, Johann Sebastian Roberts and Gorsuch, which is why that side won. Okay. Although the court relied, and this is before Justice Amy Coney Barrett got on the court. So Ginsburg is still alive at this point. Although the court relies solely on the arguments discussed above, several other arguments figure prominently in the decisions of the lower courts. And in briefs submitted or in support of the employees. Submitted by or in support of the employees. The court apparently finds these arguments unpersuasive, and so do I, but for the sake of completeness, I will address them briefly. Number one argument which relies on our decision in Price Waterhouse versus Hopkins, that's in 1989, plurality opinion, is that discrimination because of sexual orientation or gender identity violates Title VII because it constitutes prohibited discrimination on the basis of sex stereotypes. The argument goes like this. Title VII prohibits discrimination based on stereotypes about the way men and women should behave. The belief that a person should be attracted only to persons of the opposite sex, and the belief that a person should identify with his or her biological sex are examples of such stereotypes. Therefore, discrimination on either of these grounds is unlawful. Page 1764. This argument fails because it is based on a faulty premise, namely that Title VII forbids discrimination based on sex stereotypes. It does not. Of course, back then in 1964, they called them radiotypes. It prohibits discrimination because of sex, and the two concepts are not the same. That does not mean, however, that an employee or an applicant for employment cannot prevail by showing that a challenge decision was based on a sex stereotype. Such evidence is relevant to prove discrimination because of sex, and it may be convincing where the trait that is inconsistent with the stereotype is one that would be tolerated and perhaps even valued in a person of the opposite sex. Much of the plaintiff's evidence in Price Waterhouse was of this nature. The plaintiff was a woman who was passed over for partnership at an accounting firm, and some of the adverse comments about her work appeared to criticize her for being forceful and insufficiently feminine. The main issue in Price Waterhouse, the proper allocation of the burdens in a so-called mixed motives Title VII case, is not relevant here. But the plurality opinion, endorsed by 4 justices, commented on the issue of sex stereotypes. The plurality observed that sex stereotypes do not inevitably prove that gender played a part in a particular employment decision, but can certainly be evidence that gender played a part. And the plurality made it clear that the plaintiff must show that the employer actually relied on her gender in making its decision. Plaintiffs who allege that they were treated unfavorably because of their sexual orientation or gender identity are not in the same position as the plaintiff in Price Waterhouse. In cases involving discrimination based on sexual orientation or gender identity, the grounds for the employer's decision that individuals should be sexually attracted only to persons of the opposite biological sex or should identify with their biological sex apply equally to men and women. Heterosexuality is not a female stereotype. It is not a male stereotype. It's not a sex specific stereotype at all. To be sure, there may be cases in which a so-called gay, I think he means homosexual because I'm gay, but I'm not homosexual. Do you know when I knew I became, do you know when I knew I was gay, when I found out? I was reading the dictionary. I just finished the letter F. I was early in the G's. I can't remember exactly where. And I looked up and I said to my wife, I think I might be gay. I looked back at down at the dictionary at the page I was reading. Again, I can't remember where it was. It was early in the G's. And I was like, I'm gay. Holy crap, I'm gay. And so I told my wife, and she looked at what I was looking at, and she said, I'm gay too. And then we looked at we got later we got to the M's. We were in MARRIAGE, and it said a union between a man and a woman by which they are or become husband and wife, a sui generis relationship. And I looked at my wife and I said, we have a gay marriage. It's extremely gay. And not only that, I think every marriage should be gay. Every marriage should be as gay as possible. Let's help people have gay marriages. And so that's what we do. We help Christians have gay marriages. And that's one of our missions in life. There's nothing about being gay that would get you fired. And so there's no need to protect being gay. But that's me. I think he's talking about homosexuality, which is in the H of the dictionary, one letter over. You got to review the alphabet here. That might be part of the problem. To be sure, there may be cases in which and I'm just reading what Alito says, gay, lesbian, or transgender individual. I think he means, to be sure, there may be cases in which a homosexual or a so-called transgender individual can make a claim like the one in Price Waterhouse. That is, there may be cases where traits or behaviors that some people associate with homosexuals or so-called transgender individuals are tolerated or valued in persons of one biological sex, but not the other. But that is a different matter. Number two, let me refer to my notes here. Okay. The second prominent argument made in support of the result that the court now reaches analogizes discrimination against gays and lesbians to discrimination against a person who is married to or has an intimate relationship with a person of a different race. Several lower court cases have held that discrimination on this ground violates Title VII. And the logic of these decisions, it is argued, applies equally where an employee or an applicant is treated unfavorably because he or she is married to, or has an intimate relationship with a person of the same sex. This argument totally ignores the historically rooted reason why discrimination on the basis of an interracial relationship constitutes race discrimination. And without taking history into account, it is not easy to see how the decisions in question fit the terms of Title VII. Recall that Title VII makes it unlawful for an employer to discriminate against an individual because of such individual's race. So, if an employer is happy to employ whites and blacks but will not employ any employee in an interracial relationship, how can it be said that the employer is discriminating against either blacks or whites because of such individual race? This employer would be applying the same rule to all its employees, regardless of their race. The answer is that this employer is discriminating on a ground that history tells us is a core form of race discrimination. It would require absolute blindness to the history of racial discrimination in this country not to understand what is at stake in such cases. A prohibition on race mixing was grounded in bigotry against a particular race and was an integral part of preserving the rigid hierarchical distinction that denominated members of the black race as inferior to whites. Let me take a sip of water really quick. I'm going to mute it. Discrimination because of sexual orientation is different. It cannot be regarded as a form of sex discrimination on the grounds that applies in race cases, since discrimination because of sexual orientation is not historically tied to a project that aims to subjugate either men or women. An employer who discriminates on this ground might be called a homophobic or transphobic. It's interesting they don't say gay phobic or lesbian phobic, even though they like those terms for some reason. Well, why all of a sudden they drop them when they add the phobic word? Guess it's a little clunky, isn't it? Yeah, homophobic or transphobic, but not sexist. Yeah, and the phobia issue too is interesting. Why are you bringing up fear all of a sudden, as if fear is somehow an indication of moral inferiority? Fear doesn't necessarily imply anything about morality at all. I don't know what the let alone illegality. So, number three, the opinion of the court intimates that the term sex was not universally understood in 1964 to refer just to the categories of male and female. And while the court does not take up any alternative definition as a grounds for its decision, I will say a word on this subject. Now, I got to interject here and mention he says more than just one word in what follows. So if you're confused, you're about to be confused. I already was confused for you. As he says a bunch of words, and I go back and he says, well, yeah, he says, I will say a word on this subject. And then he said a bunch of words. You know, all right, Alito. As previously noted, see, there's three words right there. I will say a word on this subject, period. And then right after that, he says, as previously noted, comma, the definition. I mean, are you counting? I'm counting a lot more than just one word there. As previously noted, the definitions of sex in the unabridged dictionaries in use in the 1960s are reproduced in Appendix A. By the way, check out the appendix. It's not just a vestigial organ. Anyone who examines those definitions can see that the primary definition in every one of them refers to the division of living things in two groups, male and female, based on biology. I would have said based on biological phenomena. That's me. Biology studies biological phenomena. Biology is not the same thing as those phenomena. And most of the definitions further down the list are the same or very similar. In addition, some definitions refer to heterosexual acts. Notice how there's not two words for heterosexual. There's not one word for male heterosexuals and another word for female heterosexuals. It's just heterosexual, right? Yeah, we're not trying to stack the deck here in terms of some kind of political agenda here. 1766. Aside from these, what is there? One definition, to neck passionately, Random House Dictionary, refers to sexual conduct that is not necessarily heterosexual. But, and don't get too excited, there's only one T there, but it can be seriously argued that one of the aims of Title VII is to outlaw employment discrimination against employees, whether heterosexual or homosexual, who engage in necking. And that's supposed to be a question. I screwed that up. Can it be seriously argued that one of the aims of Title VII is to outlaw employment discrimination against employees, whether heterosexual or homosexual, who engage in necking? And even if Title VII had that effect, that is not what is at issue in cases like those before us. That brings us to two remaining subsidiary definitions, both of which refer to sexual urges or instincts and their manifestations. See the fourth definition of the American Heritage Dictionary, and that's in the appendix. These are mentioned. He's just going through the evidence here. And the fourth definition of both Webster's second and third, Webster's Third International Dictionary, since both of these come after three prior definitions that refer to men and women, they are most naturally read to have the same association. And in any event, it is plausible that Title VII prohibits. Is it possible? Is it plausible that Title VII prohibits discrimination based on any sexual urge or instinct and its manifestation? The urge to rape? Whoa. Where do you come up with that one? That's a humdinger. Viewing all these definitions, the overwhelming impact is that discrimination because of sex was understood during the era when Title VII was enacted to refer to men and women. The same is true of current definitions, which are reproduced in Appendix B, also worth looking at. This no doubt explains why neither this court nor any of the lower courts have tried to make much of the dictionary definitions of sex just discussed. Okay. Okay. Huh. Let me go back up a couple. As previously noted, I'm in number three. the definitions of sex in the unabridged dictionaries in use in the 1960s are reproduced. Anyone who examines those definitions can see the primary definition in every one of them refers to the division of living things into two groups, male and female. In addition, some definitions refer to heterosexual acts, coitus, sexual intercourse in Random House and American Heritage dictionaries. Aside from these, what is there? One definition, to neck passionately. Random House Dictionary refers to the sexual conduct that's not necessarily heterosexual, but can it be seriously argued? Okay, we covered that. That brings us to two remaining subsidiary definitions, both of which refer to sexual urges or instincts and their manifestations. For example, the sexual urge or instinct as it manifests itself in behavior, phenomena of sexual instincts and their manifestations. Since both of these come after three prior definitions that refer to men and women, they are most naturally read to have the same association. In any case, is it plausible that Title VII prohibits discrimination based on any sexual urge or instinct and its manifestation? Okay, that's the argument there. He gave a reductio ad absurdum ending in a rhetorical question. Okay. Roman numeral 2, letter A. So far, I have not looked beyond dictionary definitions of sex, but textualists like Justice Scalia do not confine their inquiry to the scrutiny of dictionaries. Dictionary definitions are valuable because they are evidence of what people at the time of a statute's enactment would have understood its words to mean, but they are not the only source of relevant evidence. And what matters in the end is the answer to the question that the evidence is gathered to resolve: how would the terms of a statute have been understood by ordinary people at the time of enactment? Justice Scalia was perfectly clear on this point. The words of a law, he insisted, mean what they conveyed to reasonable people at the time. Leading proponents of Justice Scalia's school of textualism have expounded on this principle and explained that it is grounded on an understanding of the way language works. As Dean John F. Manning explains, the meaning of language depends on the way a linguistic community uses words and phrases in context. Here's a quotation. One can make sense of others' communications only by placing them in their appropriate social and linguistic context. And this is no less true of statutes than any other verbal communications. That's a Columbia Law Review article, 2006. So there's different, here's another quotation. Statutes convey meaning only because members of a relevant linguistic community apply shared background conventions for understanding how particular words are used in particular contexts. Therefore, judges should ascribe to the words of a statute what a reasonable person conversant with applicable social conventions would have understood them to be adopting. Columbia University Law Review. Or to put the point in slightly different terms, a judge interpreting a statute should ask what one would ordinarily be understood as saying, given the circumstances in which one said it. Harvard Law Review on that one. Judge Frank Easterbrook has made the same points. Here's a block quotation. Quote, words are arbitrary signs having meaning only to the extent writers and readers share an understanding. Language in general and legislation in particular is a social enterprise to which both speakers and listeners contribute, drawing on background understandings and the structure and circumstance of the utterance. Unquote. That's Herman versus Cencom Cable and Associates, 1992, Seventh Circuit. Consequently, slicing a statute into phrases while ignoring the setting of the enactment is a formula for disaster. You don't have to be a Ludwig Wittgenstein or a Hans-Georg Gadamer to know that successful communication depends on meanings shared by interpretive communities. Thus, what textualism is properly understood, it calls for an examination of the social context in which a statute was enacted, because this may have an important bearing on what its words were understood to mean at the time of the enactment. Textualists do not read statutes as if they were messages picked up by a powerful radio telescope from a distant, utterly unknown civilization. Statutes consist of communications between members of a particular linguistic community, one that exists in a particular place and particular time, and these communications must therefore be interpreted as they were understood by that community at that time. Makes sense to me. For this reason, it is imperative to consider how Americans in 1964 would have understood Title VII's prohibition of discrimination because of sex. To get a picture of this, we may imagine this scene. Suppose that while Title VII was under consideration in Congress, a group of average Americans decided to read the text of the bill with the aim of writing or calling their representatives in Congress and conveying their approval or disapproval. What would these ordinary citizens have taken discrimination because of sex to mean? Would they have thought this language prohibited discrimination because of sexual orientation or gender identity? Again, he ends with a rhetorical question. Alito, you got to drive the point in. You can't end with a rhetorical question. You got to end with a statement. I know a rhetorical question is a statement in disguise, but I'm talking about you got to end with a statement not in disguise. If it's a reductio ad absurdum, you got to drive the point in. That's absurd. Therefore, we need to reject the court's premises, the problematic premises that led to their problematic conclusion. B, letter B, as in doll. Just kidding. Letter B is in boy. Let me just look here. Okay. Letter B is in boy. The answer could not be clearer. In 1964, ordinary Americans reading the text of Title VII would not have dreamed that discrimination because of sex meant discrimination because of sexual orientation, much less gender identity. Very good. Very good. Very good. The ordinary meaning of discrimination because of sex was discrimination because of a person's biological sex, not sexual orientation or gender identity. The possibility that discrimination on either of these grounds might fit within some exotic understanding of sex discrimination would not have crossed their minds. Number one, we're in Roman numeral 2b1. In 1964, this is the Alito dissent, joined by Thomas in Bostock versus Clayton County, Georgia, 2020, U.S. Supreme Court. In 1964, the concept of prohibiting discrimination because of sex was no novelty. We're at 1768 in the Supreme Court report or pagination on Google Scholar. It was a familiar and well understood concept, and what it meant was equal treatment for men and women. Long before Title VII was adopted, many pioneering state and federal laws had used language substantively indistinguishable from Title VII's critical phrase, discrimination because of sex. For example, the California Constitution of 1879 stipulated that no one on account of sex could be disqualified from entering upon or pursuing any lawful business, vocation, or profession. That's Article 20, Section 18, emphasis added. He italicized on account of sex. That was the emphasis. It also prohibited a student's exclusion from a state university department on account of sex. That's Article 9, Section 9. Wyoming's first constitution proclaimed broadly that both male and female citizens of the state shall equally enjoy all civil, political, and religious rights and privileges. And then provided specifically that in none of the public schools shall distinction or discrimination be made on account of sex. Okay, the university shall be equally open to students of both sexes, it says. Washington's Constitution likewise required ample provision for the education of all children without distinction or preference on account of sex. 1889. The Constitution of Utah, adopted in 1895, provided that the right to vote and hold public office shall not be denied or abridged on account of sex. And in the next sentence, it made clear what on account of sex meant, stating that both male and female citizens shall enjoy equally all civil, political, religious rights and privileges. The most prominent example of a provision using this language was the 19th Amendment, ratified in 1920, which bans the denial or abridgment of the right to vote on account of sex, U.S. Constitution, Amendment 19. Similar language appeared in the proposal of the National Woman's Party for an Equal Rights Amendment. As framed in 1921, this proposal forbade all political, civil, or legal disabilities or inequalities on account of sex or on account of marriage. Similar terms were used in the precursor to the Equal Pay Act, introduced in 1944 by Congresswoman Winifred C. Stanley. It proclaimed that discrimination against employees in rates of compensation paid or on account of sex was contrary to the public interest. In 1952, the new Constitution for Puerto Rico, which was approved by Congress, prohibited all discrimination on account of sex. In 1958, the International Labor Organization, a United Nations agency of which the United States is a member, recommended that nations bar employment discrimination on the basis of sex. In 1961, President Kennedy ordered the Civil Service Commission to review and modify personnel policies to assure that selection for any career position is hereinafter made solely on the basis of individual merit and fitness without regard to sex. That's a direct quote. He concurrently established a commission on the status of women and directed it to recommend policies for overcoming discriminations in government and private employment on the basis of sex. Again, a direct quote. In short, the concept of discrimination because of, on account of, or on the basis of sex was well understood. It was part of the campaign for equality that had been waged by women's rights advocates for more than a century. And what it meant was equal treatment for men and women. Number two, discrimination because of sex was not understood as having anything to do with discrimination because of sexual orientation or transgender status. Any such notion would have clashed in spectacular fashion with the societal norms of the day. For most 21st century Americans, it is painful to be reminded of the way our society once treated And here's his words: gays and lesbians. I think we've always treated happy people fine. We like having happy people around. Lesbians, I think those are people from the island of Lesbos. And I don't think I know anybody from Lesbos. I think he means homosexual. I'm going to just reinterpret that to mean homosexual. For most 21st century Americans, it is painful to be reminded of the way our society once treated homosexuals. But any honest effort to understand what the terms of Title VII were understood to mean when enacted must take into account the societal norms of that time. And the plain truth is that in 1964, homosexuality was thought to be a mental disorder, and homosexual conduct was regarded as morally culpable and worthy of punishment. In its then most recent Diagnostic and Statistical Manual of Mental Disorders, 1952, DSM-1, the American Psychiatric Association, APA, I thought it was the American Psychological Association, but okay, classified same-sex attraction as a sexual deviation, a particular type of sociopathic personality disturbance. And the next edition, issued in 1968, similarly classified homosexuality as a sexual deviation. It was not until the sixth printing of the DSM-2, 1973, that this was changed. We're on page 1770 of the Supreme Court Reporter. Society's treatment of homosexuality and homosexual conduct was consistent with this understanding. Sodomy was a crime in every state but Illinois and in the District of Columbia. A law enacted by Congress made sodomy a felony punishable by imprisonment for up to 10 years and permitted the indefinite civil commitment of sexual psychopaths in an act of June 9th, 1948. This view of homosexuality was reflected in the rules governing the federal workforce. In 1964, federal agencies could deny homosexual men and women employment because of their sexual orientation, and this practice continued until 1975. GAO, talking about security clearances. But not just security clearances, though, because here's one affirming a dismissal for a postal employee for homosexual acts. Okay. 1964, individuals who were known to be homosexual could not obtain security clearances, and any who possessed clearances were likely to lose them if their orientation was discovered. A 1953 executive order provided that background investigations should look for evidence of sexual perversion, as well as any criminal, infamous, dishonest, immoral, or notoriously disgraceful conduct. Until about 1991, when agencies began to change their security policies and practices regarding sexual orientation, there were a number of documented cases where defense civilian or contractor employees' security clearances were denied or revoked because of their sexual orientation. Just reading through some of the references here. You got Adams versus Laird upholding denial of security clearance to defense contractor employee because he had been engaged in repeated homosexual acts. Webster versus Doe, 1988, concluding that a decision to fire a particular individual because he was homosexual fell within the discretion of the Director of Central Intelligence under the National Security Act of 1947 and was thus unreviewable under the APA. Okay. The picture in state employment was similar. In 1964, it was common for states to bar homosexuals from serving as teachers. An article summarizing the situation 15 years after Title VII became law reported that all states have statutes that permit the revocation of teaching certificates or credentials for immorality, moral turpitude, or unprofessionalism. And the survey added homosexuality is considered to fall within all three categories. The situation in California is illustrative. California laws prohibited individuals who engaged in immoral conduct, which was construed to include homosexual behavior, as well as those convicted of sex offenses like sodomy, from employment as teachers. Teaching certificates of individuals convicted of engaging in homosexual acts were revoked. Sirac versus State Board of Education, that would be 1967, upholding revocation of secondary teaching credential from a teacher who was convicted of engaging in homosexual conduct on a public beach. But that was overruled in part in 1969. In Florida, the legislature enacted laws authorizing the revocation of teaching certificates for misconduct involving moral turpitude, and this law was used to target homosexual conduct. In 1964, a legislative committee was wrapping up a 6-year campaign to remove homosexual teachers from public schools and state universities. As a result of these efforts, the State Board of Education apparently revoked at least 71 teachers' certificates and removed at least 14 university professors. That's from Eskridge, the title Dishonorable Passions at page 103. Individuals who engaged in homosexual acts also face the loss of other occupational licenses, such as those needed to work as a lawyer, doctor, or mortician, or beautician. Florida Bar versus K, 1970, attorney disbarred after conviction for homosexual conduct in a public bathroom. Jeez. 1964, and for many years thereafter, homosexuals were barred from the military. Personnel who voluntarily engage in homosexual acts, irrespective of sex, will not be permitted to serve in the Army in any capacity, and their prompt separation is mandatory. That's an Army regulation from 1953. Prohibition against homosexual conduct by members of the military were not eliminated until 2010. See Don't Ask, Don't Tell Repeal Act of 2010. Which required members of the armed forces to be separated for repealing that statute, which required members of the armed forces to be separated for engaging in homosexual conduct. Homosexuals were also excluded from entry into the United States. The Immigration and Nationality Act of 1952 excluded aliens afflicted with psychopathic personality. This court, relying in the INA's legislative history, interpreted that term to encompass homosexuals and upheld, this is in Bootlier versus INS, 1967, U.S. Supreme Court. That's a 387 U.S. 118, 1967. This court, relying on the INA's legislative history, interpreted that term to encompass homosexuals and upheld an alien's deportation on that ground. 3 justices disagreed with the majority's interpretation of this phrase, psychopathic personality, but it apparently did not occur to anyone to argue that the court's interpretation was inconsistent with the INA's express prohibition of discrimination because of sex. That was how our society and this court saw things a half a century ago, and that was after the 1964 Civil Rights Act. I'm just adding that. That was a 1967 case. Discrimination because of sex and sex discrimination because of sexual orientation discrimination because of sex and discrimination because of sexual orientation were viewed as two entirely different concepts. I think that that follows from what he just presented. Don't you think? I don't see how you could disagree with that. To its credit, our society has now come to recognize the injustice of PAC's practices, and this recognition provides the impetus to update Title VII. Okay, here's a separation of powers point. And remember, I've been beating the separation of powers drum this whole time. Here, he's saying you may think that all those past practices were wrong, and you're free to think that. Apparently, he thinks that. Uh, but who does the updating of Title VII? Well, who created Title VII? It would be Congress. It's a legislative enactment. It's a legislative power. You may disagree, you may agree about what it says, but you can't disagree. It came out of Congress and it was signed by the president. But the majority opinion in this case, Bostock versus Clayton County, Georgia, takes itself to correct what Congress did by updating the statute, taking themselves to have the power to update for the country what the legislature is unwilling to do in 2020. That's a separation of powers problem. That's why I'm putting this in the constitutional law section, because about separation of powers. He says to its credit. Now, I mean, I don't know why you have to say this. What does this have to do with anything? To its credit, you're making a moral point here. I mean, this is not your job to make a moral point, right? It's not your job to say whether homosexuals fit into the military. That's not your job as a Supreme Court justice. But it's not like he's going to get fired for saying that. He says to its credit, okay, so he's kind of saying, I might agree with the result, but I don't agree with how you got there. He says, our society has now come to recognize the injustice of past practices, and this recognition provides the impetus to update Title VII. But that is not our job. Our duty is to understand what the terms of Title VII were understood to mean when enacted. Okay, so there's the separation of powers point there. That's what makes this a constitutional dissent, constitutional law dissent. That is not our job. Our duty is to understand what the terms of Title VII were understood to mean when enacted. And in doing so, we must take into account the societal norms of that time. We must therefore ask whether ordinary Americans in 1964 would have thought that discrimination because of sex carried some exotic meaning under which the private sector employees would be prohibited from engaging in a practice that represented the official policy of the federal government with respect to its own employees. We must ask whether Americans at the time would have thought that Title VII banned discrimination against an employee for engaging in conduct that Congress had made a felony and ground for civil commitment, not to mention deportation under certain circumstances. The questions answer themselves. Even if discrimination based on sexual orientation or gender identity could be squeezed into some arcane understanding of sex discrimination, the context in which Title VII was enacted would tell us that this is not what the statute's terms were understood to mean at the time. To paraphrase something Justice Scalia once wrote, our job is not to scavenge the world of dictionary of English usage to discover whether there is any possible meaning of discrimination because of sex that might go broad enough to encompass discrimination because of sexual orientation or gender identity. He's citing Chisholm versus Romer, 501 U.S. 380 at 410, 1991 dissenting opinion. Justice Scalia. Without strong evidence to the contrary, and there is none here, our job is to ascertain and apply the ordinary meaning of the statute. And in 1964, ordinary Americans most certainly would not have understood Title VII to ban discrimination because of sexual orientation or gender identity. The court makes a tiny effort to suggest that at least some people in 1964 might have seen what Title VII really means. But what evidence does it adduce? One complaint filed in 1969, another in 1974, and arguments made in the mid 1970s about the meaning of the Equal Rights Amendment. To call this evidence merely feeble would be generous. Okay. Good. Good job, Alito. Not bad. I want to give Alito credit, give him some cred. And I also want to suggest that you get this on paper, print it out, and make notes. You see, I have a hard copy here. I make notes. And it's a good way to go. Get yourself a pencil or a pen, have a cigar, take your time with it, flip through. The reason I do that is there's no ads. There's nothing coming up on my phone. There's nothing jingling over here. There's not like what YouTube does over here. Here's 50 million other suggestions so that you don't finish watching this, what you have on, and you go to this one, and then we're going to do the same thing when you do that. Now, here's another thing. And it's like you can't even concentrate. It's like, shut the hell up. Have a warm glass of shut the hell up, as Ben Stiller said in a movie somewhere. I can't remember where it is. Happy Gilmore, maybe? I can't remember. Okay, we're in letter C. I'm just saying, paper, dude. Paper. Kill some trees. Daggum trees. Let's keep going here. We have a little bit longer. We're almost done, okay? Letter C. While Americans in 1964 shocked, would have been shocked to learn that Congress had enacted hmm, a law prohibiting sexual orientation discrimination, they would have been bewildered to hear that this law also forbids discrimination on the basis of, quote, transgender status. Now he's got quotes around it. Well, I've been putting quotes around it the whole time, Alito. Or, quote, gender identity, unquote. Now, thank you for putting quotes around it. Just say so called. Terms that would have left people at the time scratching their heads. The term, quote, transgender, unquote, good job, Alito, so-called transgender is said to have been coined in the early 1970s. And the term, quote, gender identity, unquote, so-called gender identity, I'm adding, now understood to mean, quote, an internal sense of being male, female, or something else, unquote. Well, that's really helpful. Apparently first appeared in an academic article in 1964. I have an internal sense of being black. I'm I'm pretty sure I'm also Mexican and Incan and Mayan. And I also have an internal sense of being native Antarctican. I also have an internal sense of being something else, to use the language he just quoted. And in addition, I have an internal sense of being, ready for it? From the moon. From the moon. Where are my special rights? Where are they? Give them to me. In fact, you know what? Let's just skip the process of the rights. Just give me the money. Give me the extra money. That's really what I care about. The moon. I'm a moon person. Let's continue. None of that was Alito. That was me, just in case you didn't know. The term, quote, transgender, unquote, is said to have been coined, quote, in the early 1970s, unquote, and the term, quote, gender identity, unquote, now understood to mean, quote, an internal sense of being male, female, or something else, unquote, apparently first appeared in an academic article in 1964. You don't say. An academic article. That's a shocker. Certainly, neither term was in common parlance. Indeed, dictionaries of the time still primarily used the term, still primarily defined the word gender by reference to grammatical classifications. Any set of two or more categories, such as masculine, feminine, and neuter, into which words are divided, and that determinate agreement with or the selection of modifiers, reference, or grammatical forms. Okay. While it is likely true that there have always been individuals who experience what is now termed gender dysphoria, that is to say, discomfort or distress related to an incongruence between an individual's gender identity and the gender assigned at birth, the concurrent, the conc- the con- the current understanding of the concept postdates the enactment of Title VII. Nothing resembling what is now called gender dysphoria appeared in either DSM-1, 1952, or DSM-2, 1968. It was not until 1980 that the APA in DSM-3 recognized two main psychiatric diagnoses related to this condition, and that those would be gender identity disorder of childhood and transsexualism in adolescents and adults. That's DSM-3 at 261 through 266. The first widely publicized sex reassignment surgeries in the United States were not performed until 1966, and the great majority of physicians surveyed in 1969 thought that an individual who sought sex reassignment surgery was either severely neurotic or psychotic. Wasn't there like a 1969 film, Al Pacino? I forget what it was called. What was that? What was that film? Like he robs something. He holds people hostage, and he wants a sex reassignment surgery. I forget what it's called. It defies belief to suggest that the public, and I think it was from that time period, I think it was like 1970 or something like that, early 70s. It defies belief to suggest that the public meaning of discrimination because of sex in 1964 encompassed discrimination on the basis of a concept that was essentially unknown to the public at that time. Makes sense to me, Alito. We're now at the beginning of letter D as in boy. Just kidding. Letter D as in dog. And we're going to stop there. And I'm so curious about that Al Pacino movie that I just referenced that I want to look it up. Al Pacino movies in order. So Serpico, is that it? Might have been Serpico. It seems like it was. It's a crime drama. Let me just look and see. No, it's not. It doesn't sound right. No, I could have swore, dude. Dog Day Afternoon. I think that's what it was. Dog Day Afternoon. Crime thriller. Yeah. Um, yeah, bank robbery that goes wrong. And he wants to get, yeah, okay, it's gender search. So that's 1975. Dog Day Afternoon was the name of the film. Dog Day Afternoon. Wow. After The Godfather, you had to take that role. It's like, come on, man. A little bit. Are you a little, were you desperate? Were you worried there wasn't going to be a Godfather too? Were you worried there wasn't going to be Heat? I mean, you had so much to look forward to. You didn't need to take that role. It was a disappointing film. Anyway, thank you for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather, and I've enjoyed this time with you. I hope you've enjoyed it as well. We're almost through Bostock versus Clayton County, and we'll talk to you later. It is 12 December 2025, years after Jesus. It's a Friday.